sure that everybody's having these kinds of experiences with their own clients. I certainly have had my phone exploding over the last 6 or 8 weeks about a lot of things, particularly for some reason, fertilizer brokers and agricultural folks. So first of all, I just want to do a little bit of a primer on how U.S. sanctions work, because I think a lot of people, like, they know it happens and that it's really bad, but they don't actually understand the jurisdictional pieces of it and how they work, right? The first thing to understand about U.S. sanctions, and this comes up all the time, right, is that U.S. sanctions are an instrument of U.S. foreign policy. They're not monetary policy, they're not economic policy, they're not trade policy, they are U.S. foreign policy. And what that means is they are about leverage. They're about power, they're not about fairness, they're not about due process, they're not about any of those things, right? They are designed to make other countries and other people do what the United States wants, right? Which means it sucks to be on the other side of it. Right? They are imposed by executive order, by statutes, and by regulations in the United States. And the way that they work is the U.S. identifies a country, a person, a corporation that it wants to use as leverage, and they put them on something called the SDN list, which stands for specially designated nationals, right? Those are the people who are under sanction. Interestingly enough, you don't have to be a person to be under sanction. That includes, you don't even have to be an artificial person. You don't even have to be a corporation to be under sanction. The US routinely puts cargo vessels on the SDN list, right? And they do it not because the cargo vessel is under sanctions, but because it trips all of the bank's compliant software and stops any transactions regarding the cargo on that vessel. So they did this with Iran. They just started putting ships on the SDN list to prevent letters of credit, bills of lading, any of that stuff from going through US banks. And sanctions also include any entity that is more than 50%, or that's 50% or more owned by somebody who's on the list, even if that entity is not itself on the list. And so that puts a huge burden of compliance on anybody who's doing business, because if you're doing business with a corporation, you need to make sure that that corporation isn't under sanction, and you can't just look at the list. You have to look at the list regarding the ownership of that entity to make sure that that entity isn't 50% or more owned by somebody who's under the list. So when people talk about US sanctions, there's often this question of jurisdiction. What gives the United States the right to sanction somebody who's living in Russia, right? Where is the jurisdictional nexus for putting an oligarch on the SDN list? And what the United States Treasury will say with a straight face is that they are not exercising jurisdiction over anybody in Russia. The only thing they're doing is telling US persons who they can do business with. And US persons are all within their jurisdiction. So their view is this is not extraterritorial. It is entirely within the United States. There are a few exceptions, but they say this is about US banks, US persons, and the US dollar. So there are 3 programs that the US has instituted so far that relate to Russia. The most important one, and the one that is hitting all of these oligarchs, you know, the 400 people who were designated on like March 22nd, is what's called the Russian Harmful Foreign Activities Program. And this actually dates back to one of the very first executive orders that Joe Biden signed, which was actually aimed at hitting the Russians for malicious cyber activities related to the US election. But they use this now to say, well, anything that Russia does that is harmful in foreign countries falls under this executive order. So this is the big kahuna right now, the Russian harmful foreign activities. There's also something called the Executive Order of February 21st, 2022, which is a very lengthy name, but that was the very first sanction that the US put on Russia for the invasion of Ukraine. And then there are the 2014 historical sanctions, the Ukraine-Russia sanctions of 2014. And the reason that I say that there are these three programs is because the US sanction program with respect to Russia is very complicated. And so when you're dealing with counterparties, and a counterparty may or may not be designated, the very first question is designated under which program? Because each of these programs has a long list of general licenses that exempt kinds of transactions from the sanction list, but they're different. They're very different. So the Russian harmful foreign activities sanction program has a very broad exemption for agricultural transactions, for fertilizer, for selling or buying wheat, bananas, you know, any kind of human food, animals, animal feed, like all of those are exempted from our current sanctions against Russia under the Russian harmful foreign activities. They're not with respect to the other two sanction programs. So if you have somebody who's designated under the old Ukraine-Russia sanctions, you can't do agricultural transactions with them. So when you look at US sanctions, the question is, who's designated? And then the second question is, under what program? And then you go from there in terms of whether or not there's a permission or you can get a license to do whatever transaction you're doing. All of this is sort of prefatory to talking about what are the impacts of these sanctions right now. The first thing is direct impacts, right? US persons cannot do business with people who are on the SDN list unless they have a license or it's covered by a general license that's issued under the program, right? US persons means natural persons, corporations, any corporation that's incorporated in the United States. It includes branch offices, but not subsidiaries of US corporations. No business by US persons with those entities. That includes US banks. So that's the whole thing about not being able to do business in US dollars, which is the third thing, no business in US dollars. Please, let me say this very loud and very clear, right? If a foreign bank tells you that they can process a transaction in US dollars that is otherwise violative of the US sanction program, please do not believe them. All right? Right? Unless they're literally talking about specie, you know, about dollar bills, right? They have no control over where that transaction goes once it enters the slipstream of wire transfers, right? And there are entities and persons who have been sanctioned because they believed that assurance, and ultimately some US bank ended up processing the transaction, and a foreigner was sanctioned because they caused the US bank to violate sanctions. So, like, you know, Chinese banks, Russian banks have historically said, don't worry, we have a way to get it done in US dollars, right? You're asking for trouble. So beyond the direct effect, which is all of these US entities can no longer do this business, you know, so that's stymies trade, right? You have the secondary effect. Compliance is complicated. It takes time. People have to look at the list. They have to determine, with respect to, say, the family members of folks who are on the list, are these family members simply nominees for somebody who's on the list? Can I do business with the brother of an oligarch? Can I do business with the father of somebody on the list? Can I do business with a subsidiary corporation to one that's on the list, or a sister corporation that's on the list. Who owns what? What happens if 2 days after the sanctions, the oligarch who owned a company sells 51% of it to somebody else? Is that a real transaction? Is now the company, is it okay? Can I deal with it now? Is there a general license that applies to my transaction? Can I get a license to do my transaction? All of this is sand in the wheels of any kind of international trade. Everybody has to stop and try and figure this out. And that's when you're talking about new transactions. You've got one that's in process. It's like, can I complete it? My bank has asked me questions. Where's a copy of the license? What did the sanctions say? You know, every time you're trying to do something, I've got clients right now who have transactions. They're not even US persons, right? But they're worried that stuff is going to get caught, that the transaction is going to get caught by a bank. They're asking for indemnity letters from the other side. That's a Russian entity, that if they suffer any damage or if the money gets blocked, that loss will all fall on the other side. So then you have to stop and draft an indemnity letter in order to do a transaction that otherwise would have been, a 15-minute phone call and somebody putting bananas off of. And then you have the third level of disruption, right? Which is, what is the next step going to be? Right now, I can process this transaction. Nobody's on the SDN list, but next week, is somebody going to be on the SDN list? Is the bank going to be on the SDN list? Yesterday, the United States put Sberbank on the SDN list. Previously, they were on a lesser sanction list called the capital list. But now, no business with Sberbank at all, right? But last week, that wasn't true. You could do business with Sberbank as long as you weren't sending it, at least from a US perspective, as long as you weren't sending it through a US correspondent bank. So is the bank that I want to use going to be free of sanctions when this transaction closes? Will a bank process this transaction even though I can demonstrate to them that it's entirely legal? Right? There are a lot of banks who you can go to and say, I've got a general license that allows me to do this transaction. It's not subject to the sanctions. And the bank will say, I see your general license, we won't do it. Because we're not taking that risk. We're not spending our compliance money trying to figure out whether you're right. We don't want to investigate what your transaction is. We're a no-go on anything that relates to the Russian sanctions. Or you say you're in the agricultural business. There are lots of general licenses for agriculture. They routinely have transactions, like for instance, a US company can sell bananas to Iran, even though Iran is generally under sanction because of the agricultural license, right? But banks don't like to have to expend a lot of compliance, energy, and money on particular customers. So you can lose your banking relationships. The banks will just say, you know what, you cost us too much money. You cause our compliance department to have to research too much. We don't want to take that risk. So, if you want to do business with Russia, fine, but we're not going to process it for you. So that means that those companies have to weigh whether it's worth it to do business with people who may be under sanction, whether that's worth more to them than maintaining their banking relationships. Again, just more sand in international trade, everything taking more time and everything costing more money to get these transactions through. In terms of what one can do about this, there's not much you can do about US sanctions. What you can do is protect yourself from potential penalty or liability and get your ducks in a row in advance, know the sanctions, have counsel on it, if you're a business, have a robust compliance program so that you can show banks that you evaluate all of this and you've gone through all the analysis and all that stuff and get that done in advance to try to smooth your way. but the uncertainty piece is going to persist for quite a while because the U.S. is continuing to put more sanctions. Again, yesterday they sanctioned 2 of Putin's daughters as nominees. They put in addition to Sberbank, they put at least one other Russian bank on the SDN list. So no business that goes through them at all. And then layered on top of it, and beyond the subject of what I'm talking about, the EU sanctions, the UK sanctions, the Swiss sanctions, all of that stuff, and they're different. I mean, the EU has, I think, more people individually designated than the US does. So each time you're thinking about a transaction, if it involves Russia or a lot of sort of affiliated companies and entities, you have to start with what list are they on, what are the parameters of that program. So a lot of people have just decided it's not worth doing it at all. Again, no trade is an impairment of trade. So that's the general deal on U.S. sanctions. They're definitely a third rail. Yeah.
One question. In the case, for example, of Peruvian banks, which on a regular basis do business in the U.S. Okay? But on the other hand, there might be some Russian people trying to do business in Peru and use the services of the Peruvian banks, or legally speaking, on a regular basis. If the U.S. sanctions which are imposed would, in having in consideration that the Peruvian banks are also living in the U.S. market, will they be subject to the scope of the sanctions?
Sure. Everybody understand the question? Like, if you've got Peruvian banks who do business in the U.S., do they have to worry about complying with U.S. sanctions?
Right.
Right. Okay. The answer to that is yes and no. Right. U.S. sanctions apply to U.S. persons, generally speaking, and these sanctions apply to U.S. persons. The Russian sanctions apply to U.S. persons. Right. So Peruvian banks are probably not U.S. persons, but U.S. banks want to do business with Peruvian banks want to do business with U.S. banks. And most U.S. banks require that their correspondent banks maintain U.S. sanctions and use basically U.S. standards of compliance in order to maintain their correspondent bank accounts. Because the U.S. banks don't want to take the risk that some transaction that's legal for a Peruvian bank to do is going to flow through a U.S. bank. So U.S. banks export the sanctions programs as a matter of contract with their correspondent banks. So what Peruvian banks are going to find is that they try to do business with Russian oligarchs, their U.S. correspondents are going to shut them down.
One similar question. Are the foreign companies whose shares or local receipts are traded on U.S. stock exchanges, are these entities subject to sanctions regulation?
They are not in the technical sense, right? Because you have to be incorporated in the United States or have your principal place of business or be physically located in the U.S. Right, as a company to be subject to sanctions, right? However, again, if they're starting to violate sanctions, they're going to have trouble with the SEC and all of that. But technically, being traded on the U.S. stock exchange does not make you subject to U.S. sanctions for the most part.
I have one question. So you indicated that these sanctions are all put in place by executive order. But executive order, could potentially be exploited. How does Congress or the courts have any oversight over these executive orders?
Right. There's a fundamental underlying statutory basis for U.S. sanctions, which is the Emergency Powers Act, the IEEPA, which dates back to World War II, and that's the statutory authorization for the president to issue these kinds of executive orders. And the reason that is largely because we started with Cuba, went forward.
Right.
And there are actually statutory sanctions. We have a pretty famous law called CATSA, which hit Russia and Syria back in 2014. But most of this stuff is done by executive order. You're absolutely right, and regulatory implementation. And the answer is that there aren't a lot of checks and balances. And in fact, because we're going back to foreign policy, right? Foreign policy is the exclusive, is not the exclusive, but it is largely the responsibility of the executive branch. And they take that very seriously with respect to sanctions. So for instance, they issue sanctions as they see fit as matters of foreign policy. Congress does have some responsibility here, and they do pass legislation like the CATSA legislation. That it tends to be something that the executive seriously resents and definitely resists. So for instance, there are pieces of CATSA which the Treasury Department could now be using against Russia to do sanctions, and they're not, because they don't like that statute at all. They don't like that statute at all, and they don't like the fact that Congress was sort of meddling in what they consider to be their prerogative. So, for instance, CATSA has a provision that permits what we call secondary sanctions, where the US can sanction the relatives of somebody who is on the sanction list on the grounds that they are acting as nominees, or banks that that routinely process transactions with the US views as violative of sanctions, even if they're not US banks, right? It's to deter what they call foreign sanction evasion. And this is one place where they do actually go extraterritorial. They designate foreigners for having assisted in violation of US sanctions in their view. Okay. The Biden administration has not reached into CATSA and say, you know what, we're going to go after these secondary folks under CATSA. Instead, they're using these executive orders to go after people like Putin's daughters. It's the same concept, but they're resisting basing it in legislation because they want to keep their prerogative of this being something that the executive controls through executive order. So there's not a lot of check and balance on it. And it's not something that the US people care a whole lot about. And so it's not something that, you know, like, oh, well, we won't re-elect Biden because he did all these sanctions. That bothers us. That's not, you know, that's not something that is in general discourse.
This is something making US banks gun shy.
I'm sorry?
This is something that's making US banks gun shy of business. For example, when you say that talking about foreign sanctions, if they're offshore compliance, due diligence, then they've finally got the trust of the correspondent bank that's introducing the transaction across that to a level that's not getting money.
Yes, definitely. I mean, US banks will be very gun shy for anybody who they view as creating a sanction risk for them. And this is a place where, like when I used to do training for foreign banks on it, I'd sit in a room like this and I'd go through the foreign policy, not economic policy discussion and all that sort of thing. And I could tell within about 45 seconds who in the audience was in the compliance department and who was front office business development sort of thing. Because the business people would be saying, how can you do this? You're, you know, screwing us up. We're not able to create business. And the compliance people were saying, tell them that they can't do this, right? Compliance are the say no people. That's how they're viewed in the business, right? They're the say no people. Whatever it is, it's too complicated, it's too risky, you can't do that. So absolutely. And right now, banks are really listening to compliance. So they are de-risking like crazy. And the other people who are really de-risking on this are all of the offshore administrative functions, right? Your company secretary in the Cayman Islands, right? Those guys are all hiding under their desks because you've got a lot of offshore corporations that may have, you know, closely held 6 shareholders, and one of them is an oligarch who's been designated, right? And so they're trying to wind down, they're trying to, in some way, deal with that ownership, and you literally have folks in in the Cayman Islands who say, you know what, we're just resigning as company secretary. And so you have no way to actually affect the transactions that you need to affect in order to get away from the sanctions, because the people who have to affect it have resigned. And nobody else on the island will take the business. So that kind of stuff is happening. I mean, you want to talk about people being gun shy. Everybody's running scared on this.
Thank you
Of
very-
course, that could be a business opportunity.
Thank you very much. Great presentation. Our next presenter is Dr. Denis Philippe. He's a partner at Philippe and Partners in Brussels. His practice areas include arbitration, banking and finance law, contracts and business relationships, energy, European, Chinese and competition law, insurance and tort law, litigation and mediation, mergers and acquisitions. He's a Belgian expert for European contract law at CCBE. Is that right? Professor at the Catholic University of Louvain and at ICHEC. He's a lecturer at the Université Paris-Nanterre, editor-in-chief of the Business Law Review, member of the board of the European Law Institute, member of the French group Trans-Europe Experts. And after reading that, I need to do a lot more, I think, in my life.
Thank you very much. I have a problem with my computer. This I have not the last version of my slides, but I hope that it will be sufficiently clear for you. As you know, I have the impression that I lived the worst experience in my life through this war in Ukraine. It's really a very big catastrophe for all of us. And I would like to show what are the contractual impacts of this war. And it is to Christian.
If I can do this properly now,
Yes.
hang on. Right, so many windows open. Let's see. There.
You know this, Kate insists on this, you know all the aspects. The most important aspect is the increase of the price of energy, and the second aspect, as Kate said, that's the sanction. And you know that the export of corn is really, I know that country like Egypt are in a very serious situation at the moment. Just that you can go to the next. Just, I will not underline the sanction, okay, to do that better than I do. But anyway, in France, there are some provision with very huge imprisonment sanctions if you violate the sanction, and the same applies in Belgium. As you know, yesterday evening, the EU adopted new sanction on coal and woods, and maybe Monday it will be on oil, because it's really a big turmoil all over the country. But I'm going to see the contractual aspect. That's the sanction, but people know the sanction. Just you know that the gas price increased with 40%. I will come back on oil, and the states take some measure to master this increase of price, but anyway, all your activity, the price increase is reality. I have two small experience now during the last 15 days. The first, our law firm is legal counsel for the NG Group. The NG is producing electricity and then distributes this electricity to distributor. With the increase of price, they change their distribution modality, and now they cease the fixed price contract. Before it was possible to have during 2 or 3 years the same price for the retail of electricity, what is fairly logical. But now with the increase of price, if NG continue this business, it was really at loss. They cease to continue. And of course, there was one of the distributor. He sells 55%, 85% of his contract was a fixed price contract. Does that mean that the NG Group make a two-day advance notice to change his policy, and just the guy there is very is furious because he said all my business model is disappeared through the fact that I cannot sell anymore to my clients this kind of tax. So we try to solve that because he was aware of that since long time, but it's really a consequence of the increase of the energy price and also of the war in Ukraine. That's one example. Another example, I have one of our clients is manufacture soap and other similar products in Kortrijk, that's a region in Belgium, and he has a joint venture with a company in Rostov, this in Russia, and he is importing from Rostov linen. This linen is a kind of wheat, and with linen, which was very famous in Belgium, they can manufacture all their products. They sell these products to the distribution to the retail business like Carrefour and so on. Now the price increase is 90%. This the Aldi and Carrefour, they say no, we do not agree this price increase. It's not possible to continue like that. And this, of course, they have to find a good renegotiation deal, but it's really difficult. You see there are lots of the consequence of the sanction, but also consequence of the war, which very very huge. And this is my message. Of course, we have to renegotiate the contract, and all the clause, force majeure, and hardship are there to help parties to renegotiate the contract. And that's the next topic. That was only two examples. This first, the force majeure. Last year I make a webinar on this for the IBLC. I will not enter into too many details, but I will try to come with what is important for me. This next slide for the force majeure. You know what is the force majeure. Everybody knows that. This I will not be into detail. What you have to bear in mind is that to have force majeure, the performance of the contract must be impossible. That's really the main characteristic. When you have embargo or sanction, it's evident it's impossible. That's clear. But it's not always so clear, because you have always the possibility to have some alternative solution, and that's what makes the renegotiation important. Because normally the classic sanction for force majeure suspension, it is temporary. For instance, a sanction can be a sanction of 3 months, but and when it is dissolution, when it is definitive. And here the problem is that we don't know how long the war will have as duration. Thus that makes it difficult to see whether it's temporary or definitive. But I can come back on that if asked. This,
I'm sorry. Was I too fast? Sorry.
No, that's good. I give an example due to the COVID, but it can apply here. It's a force majeure clause. You have a contract between EDF and Total. In this contract, it was Total must. It's a bit too complex to explain the background, but Total must take off a certain quantity of electricity every year. But due to the COVID, the consumption of electricity decreased. Does that mean that Total was not able to take all this electricity from EDF? And there was a clause, a force majeure clause, saying force majeure means an external, irresistible, and unforeseeable event, making it impossible for the parties to perform their obligations under reasonable economic conditions. It's a good school case, because what does it mean, reasonable economic condition? And now the solution of the judge. Next slide. The judge said there is no definition of this term. What does it mean? There is no definition. And the judge said, however, it's linked with the occurrence of an event of force majeure, but it's possible to assume that a disruption of the previous economic condition which result in the occurrence of significant losses arising from the performance of the contract. Does that mean in this case, COVID was considered as a force majeure event, making a disruption of the economic condition? That's a good example. Just the next slides. Here you have I think what is important when you have a contract is sort of a checklist of what you have to put in your clause. I'm sure you have that, but it's only a reminder for you. I repeat, it's very important to have a force majeure clause. It's very important to foresee the clause, the renegotiation proceedings. Just I give here an example. That's a very classic clause. If the force majeure event ceases, the party shall be performed as contractually agreed or with appropriate adjustment due to the effect of a force majeure event during the suspension period. If the event, the force majeure, continue later to prevent the performance of the contract obligation and the parties in the contract become unnecessary, the parties are entitled to withdraw. This suspension and renegotiation, and then if the contract has lost its utility and if the contract is not necessary, the contract party can withdraw from the contract. This here on the arrow, you have notification, suspension, renegotiation, and then termination. That's the fourth step for a renegotiation of contract. With the next slides, you see once more the checklist I give to my students. You have the event of force majeure, for instance, the closure of the Sea of Azov. Then you have a renegotiation during 8 days, then day of performance. Then you have 60 days for renegotiation and suspension. And then after the renegotiation, termination if there is no renegotiation after 150 days. This suspension, renegotiation at the same time, and then termination and notification. That's the first, the three elements. Just the next slide. Just what is very interesting, we all are international lawyers. Everybody applies the Vienna Convention on the Law of Sales, which is a very famous text. In Article 79 of the Vienna Convention, it is foreseen that in case of impediment, the contract must not be performed. Just in case of unforeseeable impediment. The question is, what does it mean, unforeseeable impediment? Just, until the 2005-2006, impediment was considered as impossibility of performance, just force majeure. And it was really an interesting case from this case in Belgium in 2009. The Belgian Supreme Court said no, impediment can be also an economic impossibility. Does that mean that hardship and force majeure are ruled by the same law? And since then, there are a lot of legal opinion of experts of the United Nations or French trial who say that's correct. Economical impossibility is sufficient to apply this article. Just there is really a big change since the years 90, and the Belgian court was the first to apply that, and it can apply to our case of the war in Ukraine, of the increase of price, because in this case there was an increase of the price of steel with 70%. This, of course, we fall within this rule, and as you know, we all apply this convention, and it is very important convention. Next, what is also interesting as Ruben said, we apply also arbitration, and that's very interesting to see how the arbitration applies the hardship clause or the force majeure clause. Just the question is, in case of force majeure, is it possible for the arbitrator to adapt the contract? Just can the arbitrator change the obligation of both parties? Just the rule, as you know, arbitration courts are very conservative. That means that if it is foreseen in the force majeure clause that the arbitrator can renegotiate the contract, it's okay, he can do it. But if it is not mentioned, the arbitrator is not without clause, is not entitled to do it. That's a very important point. Just the arbitrator, the power of the arbitrator are limited, and he cannot adapt the contract as he wants because it's a force majeure. Force majeure is or termination or suspension, and that's it. Just he would access his power, and just the award will be annulled if he do it. Just that's important for people who do arbitration. Next. Just now, then I will come back on that later. You can go to the next slides. That's the renegotiation of contracts in case of force majeure. I will not enter into detail because we have the lunch shortly. One or two points which are important. The last paragraph, the party invoking the case of force majeure shall immediately after its occurrence send an express registered notice to the other party. Maybe registered is not important, but what we have to do as drafting of contract is to facilitate the communication between parties. And that's the notification is important. And if you have the war in Ukraine that you are not sure that you will perform the contract, you must already say, look, I fear that I cannot perform the contract. And I already notify that to you in order to negotiate beforehand. Does that mean you can already in your contract foresee that notification can also be anticipative? Dus that's very important to foresee, but you have that to be reminded. Dus when you fear that you will face force majeure, you can already renegotiate. That's important. The rest, I think, you know. The second is the clause of renegotiation, but we already, I can read it. If due to the force majeure, one of the parties prevented from fulfilling its contractual obligation for a period of more than 3 years, the contracting party shall meet to determine the conditions for the continued performance of the contract or for the termination of the contract. Because I think in all circumstances, we have to favor this renegotiation, even if it is not a miraculous solution. Next. This here, I will not enter into detail. There is suspension, renegotiation, and termination in the same clause, but I'm sure that Chris will send you this slide. So
The updated ones.
What?
I'll send the updated ones.
Yes. You can go to the next. That's also. But I will send it. You will receive this. I will not read everything. One point. The party shall take all necessary measures to minimize any damage. That's something very important. Is that you have to limit your own damage. That's what is called in English duty to mitigate. It's very important. You have to foresee that in the contract. Does that mean that if you face a sanction in Russia, but you can get the same goods from Argentina, thus you have to go to Argentina to take the goods from Argentina instead of staying there passive. Thus that's a very important obligation, which is a felony. Thus I will not enter into detail. You will see that because I have only 5 minutes. Because that was for force majeure. You said that force majeure now, there are two new trends. Force majeure is assimilated to economic impossibility in the Vienna Convention on the law of sales. And second point, renegotiation is more and more popular in the force majeure clause. That's two main aspects, especially in international trade. Thus you have to bear that in mind. And the third point is that you have to organize the notification of the force majeure and maybe to have a notification even if you fear that force majeure could occur, so that will facilitate the negotiation. That was for force majeure. Thus for hardship, that's the same principle, change of circumstances. Thus in the case of the Azov Seas, it was a case of increase of price. It's a case of hardship. And you know the main difference between hardship and force majeure is that in case of hardship, you do not need to have an impossibility. It's the upheaval of the contractual economy. This is the disruption. If you have to sell at loss, it's really a case of hardship. You can go ahead. This upheaval of the contractual economy, it can be the case of the performance of the obligation become excessively burdensome. That's the case I gave, increase of the price. The original equilibrium between the obligations is disrupted. That can be also and the purpose of the contract is frustrated. That's the three. But purpose of the contract is frustrated is not always taken into consideration in the law. Next. Dus what is also important is that no more and more the possibility to adapt the contract in case of change of circumstances is recognized in all the countries. France, and Belgium were the last bastions where it was not possible, like Asterix and Obelix. We were the last location where it was not possible. Because now it's recognized all over the world. We have also my Luxembourg friends in Luxembourg. They are still hesitating, but maybe they will come to the same conclusion. What is important here is that the legal regime is different from country to country. This, for instance, in the common law, you cannot adapt the contract in case of frustration. That's really that's the reality as far as I know. It's very difficult. Just they know the principle, but they do not apply it on the same manner as we apply it in our country. That's very very interesting to see. And in Germany, they know the concept of Wegfallgeschäftsgrundlage. Wegfallgeschäftsgrundlage is a very obscure concept, and I think they will apply also in case of disruption, but it's not so sure. Just my message: you have always to insert a hardship clause in the contract if you want to have an adaptation possible. But there are cases where you see no adaptation, and you foresee that no adaptation is possible. But anyway, you have to foresee that in your contract. That's also a bit the message here from these slides. Next. And I will, due to the fact that I have only 1 minute, I will terminate with this case because it's a very interesting case. It's an old case, but it's always very interesting. I always give it to my students. You have the impression when you have a renegotiation clause that if the renegotiation fails, that's over and that's over. But it's not true. If you see this case, it's a old case. As you know, the first oil crisis was in '73, and at that time there was a contract for a long-term supply contract between EDF and Shell for the delivery of fuel. And in this contract, that adaptation, but with the crisis in '73, the price increased very sharply, and does that mean that there was a renegotiation clause? And the parties renegotiate, but Shell has no interest in renegotiate because he would like to have the highest price, the market price, and there was a 10-year contract. But even after the termination of the contract, they continue to supply, but with a provisional price, and they say no, we have to adapt the price. The case was at the tribunal de commerce de Paris, and in first instance, they said, no, this increase, the price is not determined anymore, no contract anymore. Then the case go to the Court of Appeal in Paris, and the Court of Appeal said, no, you do not negotiate sufficiently. You have still to continue the negotiation, and in order to be sure that there will be a continuation of the negotiation, the judge appoints an observer, and the observer is there to see if parties are renegotiating very on good faith. And of course, with this observation, they come to an agreement. Only to say that renegotiation clause can really have an impact, and that's something important. And that's my last message. My message is parties are master of their destiny. It's important for you as drafter to be master of your contract, and renegotiation, I think, as really is useful. Thank you very much.
Are there any questions? Okay, I have one. In the context of a basic force majeure clause where there is no provision made for a temporary suspension or renegotiation, how do the courts decide whether the invocation of force majeure was reasonable?
Does that mean that decide whether invocation of force by a party was reasonable? Dus, the judge will see whether the condition of application of the force majeure are present. Dus if a party notifies the case of force majeure, the judge will see whether it is non-accountable, unforeseeable, and impossible. Dus that is what the judge will do. But second point, if there is no renegotiation clause, the judge cannot renegotiate. He can do that for hardship, but not for force majeure.
Thank you very much. Thank you, everyone.
One more for foreseeability. The starting point or the point that the judge looks at whether the events were unforeseeable. Is it the conclusion of the contract or is it some other date? Because in Hungary, it is the conclusion of the contract. There you have to foresee or unforesee.
That's the same. But just first, enforceability is considered on a human basis because everything is enforceable. For instance, I know that in Germany there was a report on the COVID already in 2009 saying that all the pandemics were foreseeable. They say that in a report at the parliament. And what's my second point for the answer is that we have to make a distinction between the event itself and the effects. Does that mean that you can conclude the contracts with events which are foreseeable, but you cannot see the effects of this event? That's the case for the COVID. You know, the COVID was foreseeable in February 2020, but nobody could imagine that it could take 2 years. Does that mean that the effects, and you have to judge in function of the effects? That's the same for the war in Ukraine. We don't know yet how long it will take, maybe 1 year, because of somebody. We do not know at this time the effects, but what we can do is that we can take already in consideration that it will take 2 years. What you could not do for COVID, because with COVID, nobody could imagine that it would take so much time. But that's only some reflection.
Okay. Thank you very much.
Thank you.
Pleasure.
I just did want to say, Rizba, he's new, so everybody make him welcome.
Yes.
I think we get to adjourn to lunch now until 2 p.m.
Okay.
Manuela will point the way.
Really?